and welcome to Legal and Practical Background Check Considerations. I'm Mike Coffey, President of Imperative Information Group. We are a background investigations company based in beautiful Fort Worth, Texas, and it's a great day here. Sun's out, a little bit overcast. It's just perfect because we can be blistering hot in May, and so we're really happy that a little overcast is not a bad thing. So this is the latest in our series of webinars covering how to be an effective second chance employer. This is an important message for me and has been for a long time. I've argued for years that most employers are already second chance employers. We all have people with some sort of criminal history in our employment, or at the very least, we've fairly considered them for positions. You know, we hear numbers, and we'll talk about this in a minute, of these giant, population of people with some sort of criminal history who are unemployable, can't get jobs, employers won't consider them, and that's just not true. It's hyperbole to just a really great extent. Most employers, for years, and when I was in HR and both in aerospace and in healthcare, we hired people with criminal histories. But what happens is a lot of employers are a little nervous when it gets to more serious criminal histories about how do I fairly evaluate this. They don't want to be too conservative and lock potential qualified employees out of consideration, but at the same time, they don't have real good tools to necessarily evaluate the risk somebody may pose. And quite honestly, nobody's really given them very good tools. They always get the advice to consider individuals on a case-by-case basis, but they don't get a framework on how you really evaluate those people on a case-by-case basis. So you end up going with your gut, which most of us, HR people, are by nature pretty conservative in how they select individuals for jobs. We don't want to hire people that aren't going to work out. So we tend to be, pretty risk conscious, and without a framework and without the tools to really evaluate those folks, then we may be too conservative sometimes. And I would say that's most employers, that's your prerogative, but most employers don't want to be too conservative. They want to have good tools. So we've put together this whole series of webinars, and we're doing some articles and some other tools that'll be out soon that will help employers fairly consider individuals with criminal histories. Today, we're going to talk primarily about the legal aspects around background checks coming from the federal level, primarily the Fair Credit Reporting Act, and what employers need to know when they're doing background checks. What are the requirements there? And this is a webinar I've actually done twice a year for probably 10 years, and given it HR Southwest and at other HR conferences, and I'm still amazed by how many employers are not doing this right, and you can see it because the class action lawsuits continue. So today we're going to talk a little less about second chance employment and more about your general screening process and how to make sure you're legally compliant in what you're doing on the background check side. But do go back and look at our previous webinars around how to meaningfully have conversations with your applicants around criminal history, how to fairly evaluate their criminal history, looking both at practical things that you as an employer can do, plus what the EEOC wants you to do. And I think we've got some really good tool sets out there for that now. The business case for being a second chance employer and how you can have that conversation with your executive team. So there's a series of webinars, and we've got a couple more coming up that in this series that will be helpful to you as well. So first, let's talk about, as we're talking about background checks today primarily, let's talk about your screening process. The screening process is, in my opinion, not just the background check. If it is just the background check, you don't have a very good screening process. I would argue that your screening process starts with the job description, and it includes a risk assessment for that position. So it says, this position has access to easily removable assets, cash or equipment or other merchandise. Maybe this position has access to personally identifiable information, or they work with vulnerable populations, the elderly, the infirm, children, things like that. So you go through and do that. And that's before you've ever met your applicant. You write your job description. And I argue that you should include in your job description this risk assessment right up front. This is what, in this, for our administrative clerical positions in our organization, these are the risks that they're exposed to. And then we take that information, base those risks, and look at the kinds of offenses that are relevant to those kind of risks. And we put together the criminal offense relevance matrix. And we just did a whole webinar a couple of weeks ago on that. You can go look at that on our website for free and for credit. But once you put together this risk offense or criminal offense relevance matrix, and basically what it tells you is that for this particular jobs, we as a company have determined that this particular offense is low risk if it's in the last 3 years. But maybe there's some offenses that in the last 3 years that make it a medium risk, or an offense that was 3 to 7 years ago, maybe a high risk, even though it's a little older, depending on the nature of the offense. And so we're going to categorize offenses before we've ever met an applicant with this particular history as low, medium, or high risk. And what that does, it takes bias out of your process because you've already done the risk analysis, the basic risk analysis, before you've ever met your applicant. And then you meet your applicant and you'll go through the process, and we'll talk about individualized assessment a little bit later. But you talk to your applicant, you evaluate the whole applicant. What is their skills, what's their skill, what's their experience level, what education do they have, those kinds of things, and what does their criminal history look like? And then what did they say in the interview about what they learned from that experience? And then we'll look at, okay, we said this is a medium risk position, but we look at their employment history since that offense. We look at the skills that they need and the demand in the market for those. We look at the skills that they bring and the demand in the market for those. And then we look at what did they tell us about their offense? What did they learn from that experience? What can they demonstrate to us reflects that they are not the person who made that critical error in judgment 4 years ago, 5 years ago, 6 months ago, whatever it was. And that's where we have to still be careful not to introduce bias, but having the tools already in place helps us really know that we've already identified what our concerns are. And so then we're going to look at the applicant, and this is where the case-by-case basis comes in, because you're going to be fair, and none of us are purely our criminal history, unless you're Charles Manson or something. But most people are not just their criminal history, right? And so we want to be fair and evaluate the entire applicant, but you can't do that if you don't have the information. And then the last part of your screening process is the verification piece, and basically the verification is the background check. Whether you do parts of it or you send it to your background screening company like Imperative, the screening process should just be a lie detector test. Was the applicant honest with you throughout the rest of the interview, application and interview process? If they were, then the background check should rarely affect the hiring decision because they were truthful with you from the beginning, and you already knew it, and then you ordered the background check, and the background check verified what they told you. And so if they verified what they told you, then you're in good shape. Now, if something comes back that they didn't tell you, my argument is always, if you asked them and they didn't provide the information, that means they lied to you. And if they lied to you coming in the door, you can't reasonably expect their behavior to change after you hire them. So having said all that, this is the gospel according to coffee with regard to background checks. And I will add one thing. When I say it's the gospel according to coffee, this is what I've developed working for the last 20 years, consulting with employers about their entire employee selection process, including the background check piece. But I'm not a lawyer, and I'm especially not your lawyer. So some of the stuff I may say today doesn't line up with what you guys are doing. That doesn't mean you're wrong, but you probably are, especially around the Fair Credit Reporting Act, because most employers, this is pretty black and white stuff, and most employers are in compliance at some level, but there may be something that you're missing. So do talk, if there's something that you have a question about and we don't get it in the Q&A today, feel free to shoot me an email and let's talk about it and make sure you're doing everything right, whether you're one of our clients or not. I certainly hope you're doing it right if you're one of our clients, because we certainly try to give you all the information. But if something's out there that's unclear, do reach out to me and let me know. So let's talk about the basic components of background checks first, just so that we have some ideas and kind of a common language around what we're talking about when we say background check. A good background check will always start with some sort of identity research first. Some companies call it a social security number verification or social security number trace. We call it an imperative identity research because the term verification 90% of the time isn't really what you're doing. What you're really doing is corroborating that the social security number, name, and date of birth that your applicant gave you matches the information in big data out there, information from credit bureaus, driver's license files, and other sources that the big data companies put together to identify that, yeah, Mike Coffey is really born on this date, and this is really the social. So those three things really match consistently in the big data files, the consumer reference files. And so we can be pretty confident in going forward that this person is who they say they are. Now, if somebody else is completely using all my identity information, there is no way that in the background check process we'll verify that, that the name, date of birth, and social, if everything matches, but this person is using my information, you won't catch that on the background check and the identity research process. Where you will catch it, and it's important that you do this, obviously, because it's the law, is when you're completing the I-9 at hire. That's why those documents are so important. Their driver's license or passport or whatever documents they provide in the I-9 process, you really need to look at those carefully and make sure, because that's really the biometric information you're really going to get to verify who they are. So why would an applicant lie about their identity? Well, maybe they're not eligible to work in the U.S., and certainly we see a lot of that, especially here in Texas. But we also see people trying to avoid child support, or maybe their student loans or other obligations that may result in wage garnishments. And so they give you a different social, they alter their name somehow, they screw up their date of birth, trying to make sure that when you do your mandatory wage reporting, that information doesn't flag in the Attorney General's system in the state, to make sure that they come back and issue a wage garnishment for that information. And we see that. But then there are people who are just trying to hide their criminal history. And often they understand how criminal records are stored and managed better than most employers. And so they know if they give you a different name or a slightly different date of birth, there's a good chance that you won't find their criminal records. And so they muddle with their information, and maybe sometimes if you don't really do a good job in the identity research process, you won't find that information. But on occasion, for young people who haven't established any credit or had a lot of commercial transactions like that, or somebody who's recently immigrated to the U.S., or on very rare occasions, individuals who got a new Social Security number because of identity theft. I hear from clients a lot who say this individual claims that they got a new social and that because of identity theft, and that's why we can't verify who they are. But when we take it to the next step, those claims usually prove to not be accurate. They're just either not eligible to work, or they're trying to hide who they really are. There is a next step, though. There is a way pre-employment to verify that this name, date of birth, and social all match directly with the Social Security Administration. And so if our standard initial process of verifying or corroborating somebody's identity information based on this big data, these consumer reference files, then we can go to another step, and we always contact our clients and say, hey, we're unable to really be very confident in the identity information that your applicants provided us because the data is simply not out there to support it. Or maybe your applicant's John Smith, and everything we're seeing related to this social is coming back Betty Jones. And so we know we've got some issue here. We're not going to tell you this isn't who you're dealing with, but what we're going to say is, let's go to the Social Security Administration, have your applicant fill out yet another form, a consent-based Social Security number verification form, and we will go ahead and go directly to the Social Security Administration and verify that these data items, this name, date of birth, and social, all match the Social Security number, Social Security Administration's records. Still doesn't mean that the person sitting across the desk from you is who they say they are. That's why the I-9 process is so important. And if you have questions throughout the process, go ahead and pop them in the question box, and I will answer them. Now, if you're watching live on Facebook, then I'm not paying attention to those, but I will try to jump in at the end of the webinar and look at those and see if I see anything that I can answer live. So let's talk about criminal history, because that's what most people are thinking about when we talk about background checks. So you've heard numbers that say 65 or 70 million Americans have a criminal record. Well, it depends on what you call a criminal record. That number comes from the FBI, and what it really means is that that many Americans have been arrested for a felony in the US. So that's a really high number, because a lot of the people who are arrested for offenses are never convicted or even plead deferred adjudication, or maybe there's never even a case filed. It's just an arrest, and it doesn't even get as far as a criminal case being filed. So that 70 million number is probably somewhat inflated. In fact, in a fairly recent study by the University of Georgia suggested that as of 2010, only about 3% of the US population, about 7.5 million people, had served time in prison for a felony offense. So that's only 3% of the US population we're talking about. So it's a tiny, not much smaller percentage than, you know, maybe 30% or more Americans. But that's just felonies. What about misdemeanors? What about all those people who had a conviction for a felony case but didn't go to prison for it? That gets even murkier. The data is just really kind of hard to extrapolate. We talked about this quite a bit in the first webinar in this series, but just to recap the short version, and if you get the notes if you download the notes after the webinar, you'll see all my logic behind this. But basically, I think if you look at all the misdemeanors and felonies out there, you're going to come up with a number around 57 million people in the United States have a misdemeanor or felony criminal conviction. Now, that's a wide range from misdemeanors, you know, everything from simple assault to a theft by check, all the way up to a felony murder. So that's a wide range of offenses, right? And shoplifting 20 years ago is not relevant, where murder 15 years ago may still be relevant for a lot of jobs. So we just have to remember that when we're reading these numbers, whether they're put out, even unfortunately, these numbers have been published by SHRM sometimes, and you know, not what SHRM's trying to promote in their effort to get employers to consider hiring former offenders is very admirable, but they're using a lot of the popular data without, I think, looking into it very deeply. So anyway, my message on this is that you want to look at criminal history, but the population with some criminal history is probably not as severe, especially criminal history that's relevant to the job, not as severe as you might think. You do want to know that in 2012, when we're talking about criminal history, that the EEOC came out with new guidance on employers' use of criminal history. And in our recent webinar, How to Fairly and Legally Evaluate Applicants' Criminal History Information, we went through what their expectations were and how employers can really plan in advance by doing that relevance matrix and some other tools to identify what criminal history would be really relevant to specific jobs. We won't dig deep into the Title VII stuff that the EEOC covered, because that's in the other webinar, and you can go get that on our website at any time. So beyond criminal history, we're also talking about doing kinds of verifications, calling to verify somebody, you know, calling a school to verify someone's previous education claims, or dealing with the registrar's office electronically, however that's required. Verifying their employment claims. They said they worked for this company. I'm amazed how many employers don't pick up the phone or ask their background screening company to pick up the phone and verify previous employment. There's a lot of fraud that goes on there. People claim that they were employed at places they never were employed at. We see people who really fudge the dates on when they were employed, so it looks like they were employed someplace 5 years, and you go back and it was 18 months, things like that. Some employers do check personal or professional references. There are a number of regulatory agencies that require employers to verify personal or professional references. Basically, those are just intelligence tests. Is the person smart enough to list 3 people who'll say nice things about them? but on occasion you get relevant information out of those too. So we want to verify those claims that these applicants have made about their experience, who they, and their reputation. We want to try to verify those. Now, if you pick up the phone and call a previous employer, that is not a consumer report, and the Fair Credit Reporting Act doesn't apply to it. And we're going to talk more about the Fair Credit Reporting Act, obviously, in a minute, but I want to point that out, because if an employer is just picking up the phone and making the call, then it's not a consumer report. However, if you go online to either the work number to verify somebody's previous employment through a company that uses the work number to verify that information, or the National Student Clearinghouse to verify someone's education claims, even though you're doing that directly as the employer, you're not going through your background screening company, it's still a consumer report because you're paying a third party for that information. So it's a consumer report at that point. So you do need to follow all of the FCRA stuff in these cases. Then driving records, certainly a lot of employers, probably 3/4 of our clients run driving histories. While they do verify that somebody has a safe driving history, I recommend looking at MVRs, driving histories, even when the applicant won't necessarily be driving. In cases where they may be operating heavy equipment or some sort of dangerous equipment, it may give you some insight into their safety awareness and their compliance to safety rules. Certainly, if somebody had a really negative driving history, I'd think twice before letting them operate a crane or a forklift or any kind of heavy equipment like that, or maybe even operate industrial machinery that really needs a high level of safety awareness. Another thing that the driving history will do, it's another verification that name and date of birth and address provided to you by the applicant matches a government record, because you'll get that information on the driving history. So that's another quick identity verification piece. And then it may, even if the person never drives, you may see red flags on there, like their driver's license is suspended or it's invalid for some reason. And you want to know why, okay? As an employer, that's relevant. Is there something else out there? Do they have warrants for their arrest someplace and it's impossible for them to renew their license because of those warrants? Or maybe their license has been suspended because of a pending criminal case, a DWI or something like that. Things that would tell you there's something else to look here. You see a suspended or invalid driver's license, there's something going on there, and you'll give you an opportunity to dig a little deeper into it. And then some employers do look at credit for certain positions. Now, I spend more time talking employers out of using credit than using it, because often employers want to run it because it's instant, it comes back instantly, and it's pretty general. You look at it and it's either positive or negative, right? Either somebody's paying their bills on time, or you see a lot of accounts that are slow pays or in collections. But then what does that tell you? I've had a number of employers over the years say, well, that suggests that if somebody's not has got really negative credit, maybe they're more likely to steal from us. Possibly, but there are a lot of reasons people have negative credit. A job loss or a spouse's job loss, or maybe a medical situation, either with them, which you definitely don't necessarily want to know about during the applicant process, during the because of the ADA, but also maybe their spouse had some sort of health issue, or a kid, things that you don't always want to know. So I recommend only really looking at credit where somebody has fiduciary responsibility on behalf of the company or the client. They're managing company accounts or credit cards, things like that, or they're in a really high-risk position where they have access to personally identifiable information or other sensitive information. But if you set whatever criteria you set for when you run a credit report, once you get it back and it's negative, you need to have a conversation with the applicant about it, right? So that you're fair about it. You don't want to lose a good candidate just because they've got a negative credit history, but there's a perfectly good reason and understanding for it. So you got to have that conversation, which can be kind of icky, right? We don't want to get into this personal stuff, but if you're going to use credit, I really think you've got a responsibility to both to your company and to the candidate to have a frank conversation with them about it and find out what's going on here. Why is this so negative? Now, if they want to get too much into their personal life, you have to cut that off pretty quick because, first of all, a lot of it's not relevant. But secondly, you could get into some more information that's it puts them in a protected class than you really want to know about sometimes. But whatever they tell you, make sure you document that well so that you can defend your use of it later. But if they come back and tell you, you know, if they make excuses for their credit and it's clear that this is just a self-management issue, that if there's no other, you know, no unusual circumstances, then maybe if I'm going to hire somebody who's going to have, you know, financial responsibilities in my organization, I do want to think twice. If they're not managing their own business well, I'm not going to let them manage my business in that area as well either. I may put them in other kinds of jobs, but if they don't manage money well, then that may tell, you know, that may tell me that, well, I'm not going to put them in a position where they're making decisions on behalf of the company or clients. Not because I necessarily think they're going to steal, but just because they've not exercised good judgment in the way, you know, in a way that we would like to see when evaluating somebody with a history or with a negative credit history. So the Fair Credit Reporting Act is the federal law that governs consumer reports. So ignore the word credit in the title of this law. It should really be the Fair Consumer Reporting Act because it deals with consumer reports. And basically a consumer report is when anytime in the employment context, is anytime you as the employer go and purchase information about an employee or a candidate from a third party that you're going to use to make an employment decision. Okay, and we'll talk about what an employment decision is in just a second. But so that's what a consumer report is. Ignore the word credit. And in most cases where you're paying for information about an applicant or an employee, it's a consumer report. Why are we hung up on FCRA? Because it's easy to build a class action against an employer for failing to follow the FCRA. And a lot of these class action lawsuits are for pretty minuscule violations of the FCRA. The damages under the FCRA are like $1,000, but it's $1,000 per person, per instance. And so if you're consistently doing things wrong under the FCRA, it makes it easy for a plaintiff's lawyer to come and build a class action lawsuit against you. And most of these settle, but when they go to trial, employers often lose them as well. And when you get the notes, and you can go on our website, and a lot of these are documented, but these are high dollar lawsuits that get really expensive for employers. So when we say the Fair Credit Reporting Act applies to individuals to companies or employers who are buying information about applicants or employees for employment purposes, what does that mean? Well, the FCRA, the Fair Credit Reporting Act, identifies an employment purpose as evaluating a consumer, an individual, for employment, promotion, reassignment, or retention as an employee. So we're going to run an annual driving history on you as an employee, and we're going to buy it from our background screening company. That is a consumer report, and the employment purpose is to continue your employment as a driver, because if you've got a really negative driving history, we may take some action against you. And it may not even be firing you. It may just be moving you to another job or adding points to your system, to your score as a driver in our organization, adding points that if you get to a certain point, too many points, you can't drive in our organization, things like that. That would be an employment purpose under the FCRA. Now, the Federal Trade Commission has also said that contract employees, 1099 employees, if you run background checks of any kind on them, the Fair Credit Reporting Act applies to those folks as well. And certainly, if you're hiring an outside consultant to come in, anything like that, that would the background check that you hopefully do on those people would come in as well as a consumer report. Now, the Federal Trade Commission also says this applies to your volunteers. I disagree with them on that. However, it's probably still smarter to follow the Fair Credit Reporting Act. It's not a lot more work, and to follow the FCRA. We've worked with some of our clients who have a lot of volunteers. to develop a process that where you're not suggesting that they're employees, because you never want a volunteer to be treated like an employee just for, you know, to avoid any future FLSA or other kinds of claims. So we want to make sure that we don't treat them like employees, but we can still follow the FCRA process to an extent to make it look like, hey, we were trying to really follow the FCRA, be fair and open with the volunteer, but without suggesting to the employer or to the volunteer that they are an employee. We've got a couple questions. Let me jump in here real quick. Oh, well, I think maybe we answered that, but I'll jump down to the next one. Okay, what about, the other question was, what about, we're talking about criminal history, when you've got an applicant who has where they've got to get some sort of security clearance or some sort of regulatory approval, and you know that the regulatory agency is probably not going to approve them. Well, if it's an absolute bar to employment, if and this is really under Title VII, not FCRA, but if it's an absolute bar to employment to consider somebody with this criminal history, then you've got a lot lower risk of a Title VII violation if it's a federal law that's barring them from, a federal law or federal regulations barring them from the job. I wouldn't worry so much about a Title VII violation. Now, if it says, you know, if just your experience is that people with felonies don't get approved, but there's not a regulation that absolutely bars them, in that case, I would probably err on the side of, if they're otherwise qualified and it's somebody you would want to hire, I would err on the side of letting the agency make that decision rather than putting you at risk of creating a disparate impact of some sort under Title VII. Okay, so back on the FCRA, there's a special kind of consumer report called an investigative consumer report. And we're not going to get very deep into it, but when you call an employer, a previous employer for one of your candidates, and they give you, title, date of hire, date of termination, maybe separation reason if you're lucky, maybe they give you eligibility for rehire, just real black and white stuff. That's stuff that they maybe store in their HRIS system. That's just a plain old consumer report, standard information. But if your background screening company calls, but also asks questions like we always ask for our clients, was there ever a reason to question their integrity or their honesty? Did they ever act in a threatening or coercive manner? What was the relationship like with their coworkers? Things like that. What kind of leader were they in your organization, depending on the role you're looking for? So you ask those kind of questions, or your background screening company actually asks those kinds of questions on your behalf. That makes this report an investigative consumer report, because we're basically doing an interview now. And so, just as though we went next door and talked to the applicant's next door neighbors like they might have security clearance, that's certainly an investigative report. We would do the same, when we're talking to previous employers and just trying to find out more information about this applicant. And you'd be surprised, probably, I would guess about 40% of the time, we get information back from previous employers about that kind of performance. But that makes an investigative consumer report. And this is just relevant because in your disclosure and authorization document under the FCRA, there's got to be specific language in there about the investigative consumer report. And so my recommendation is always just include it in the disclosure and authorization language on your background check authorization form, so that it's always covered if something comes up later. Now, if you, the employer, pick up the phone and call those references directly, you call those previous employers directly, you call schools directly, you're not coming through the background screening company, you're not coming through the work number or the National Student Clearinghouse or agencies like that, then it's not a consumer report. If the information comes directly from that direct source because it's coming directly from that other party's interactions directly with the consumer. So also when, I have a lot of conversations with applicants and candidates, often the ones who didn't get the job, and they're upset because they think it's unfair that the employer didn't hire them or whatever. Okay, well, we understand that, but I tell them we didn't make the hiring decision, but is the information on your report accurate? Do you believe that's an accurate representation of your criminal history or why you terminated from this employer? And 99% of the time they admit, yes, it's accurate, but I just don't like it. Well, okay, I understand that. But how they treat me on that phone, if they're abusive and they're cussing and they're throwing a fit, which sometimes they are, and I tell the employer that, that's not a consumer report. So when I'm talking about my experiences with your applicant directly to you, that's not a consumer report either. Just like if you picked up the phone and talked to a previous employer yourself, that wouldn't be a consumer report. And there is an exception in the Fair Credit Reporting Act for third-party investigations. So if you hire an investigator or an HR consultant or something like that to come in and do an investigation, or your own legal counsel comes in and does an investigation, that's not a consumer report under the FCRA. However, you do have a responsibility in those situations to provide certain information to the individual at the conclusion of the investigation if you're going to take some adverse action, employment action against them based on the investigation. Basically, you have to disclose to them the nature and substance of the investigation that you're taking this action on. So you don't have to tell them, Mary said you were a thief, Joe said you were a thief, and Susie said you were a thief. But you have to say, we conducted, had an outside party come in and conduct an investigation into the theft of this property, and several employees told us they saw you pick it up and carry it away. But you don't have to name names or do anything like that where you would have to be concerned about retribution against those witnesses. So just know that when that happens, you've got responsibilities, and you'll want to look at those responsibilities when that need arises. So another thing you need to know about FCRA is it limits what I, as a background screening company, can tell you. There's basically a 7-year rule. So convictions under federal law and under most states' laws are reportable forever. Okay, so criminal convictions, if it ended with an actual conviction, it's reportable forever. Now, non-convictions, deferred adjudication, dismissed cases, even arrest or civil cases civil cases are not criminal convictions, negative employment information, things like that, that's all reportable for up to 7 years, unless the person's going to make more than $75,000 a year. If they're going to make more than $75,000 a year, there's no limitation under federal law and under most states' laws about what you can report. It's if they make more than $75,000, everything's available to you. But there are some state limitations as to what an employer can receive from their background screening company. 8 states have some prohibition from employers reporting information older than 7 years. A few states have, Colorado, Massachusetts, and Texas have limits on their books in the state law, but those were preempted by the federal law when they changed the federal law in 1996. But some states had laws on their books before 1996. California, Montana, New Mexico just have a flat 7-year prohibition on reporting information older than 7 years. And then a few states, Kansas, Maryland, New Hampshire, and Washington have a 7-year limit on reporting convictions, except they've got really low thresholds. So if a person's going to make more than $20,000 a year, then in most of those states, the employer can consider convictions older than 7 years. That limit's only for positions less than 20,000, which makes no sense to me, but that's their rule. And then New York State has one for at a $25,000 threshold. So just know, depending on where the job is and where your applicant lives, your background screening company may see stuff that they can't legally tell you. Now, the problem is, and you need to check this with your background screening company, most companies are in states like Texas where there is no limit on reporting convictions. And that means that if we see something at Imperative, we see a criminal record that's 15 years old or 30 years old, because a lot of the court's computers go back that far, and if we see that this person has a conviction 30 years ago, we're still going to tell the employer about it. And you need to make sure your background screening company is doing that. There are background screening companies that only report convictions in the last 7 years. Our background screening companies don't even report deferred adjudication. So those are cases where the individual pled guilty to the offense, served probation, and the background screening company won't tell the employer, even if the employer is located in a place where they can legally use it. So you need to understand from your background screening company exactly what they're going to report. Then when you first sign up with your background screening company, you should have to make certain certifications to them. And that's a good sign if you can go online and do the background check, and it's just a little, pay the flat fee, and you're not certifying that you have a legally permissible purpose under the Fair Credit Reporting Act, and that you're going to follow all the Fair Credit Reporting Act requirements. There's a whole list of certifications you should be making, and they're all in the notes when you get those. Then it's a red flag that this may not be a source that's appropriate for use. Just because you can get the criminal history information from a from some website doesn't mean it's legal for you as the employer to use under the Fair Credit Reporting Act. And so you want to make sure that whatever your source is, that it's FCRA compliant. And one of the ways to look for that is to make sure that that they're requiring you to certify to them a lot of things about who you are and why you're asking for this information. So here's where employers really start getting in trouble, though. You've got to make a disclosure to the consumer, the applicant, the employee, whatever you want to call them, whether it's the current employee you want to run a background check on or a prospective employee. You've got to disclose to them that you're going to procure a consumer report, the background check, from a third party before you order it, okay? And that disclosure has to be on a document used exclusively for that purpose. Then you also have to get their authorization to procure that consumer report. Now, the disclosure has to be, like I said, on a document used exclusively for that purpose, but the authorization can be the small print at the back of your employment application. Most employers combine the two so that they get the signature and they've got proof that they gave that disclosure to the individual because they've signed it with the authorization, which is what we do at the bottom of our document. It's got the disclosure or the authorization, and then the top of the document has the disclosure language. Where employers get into a lot of trouble, though, is in their disclosure language. They include on what's supposed to be a separate document used exclusively for the disclosure and authorization purposes, they add additional information into that disclosure. Releases of liability. I release the company from this liability, or I authorize all previous employers to provide this information to the company, to the employer, rather than to the screening company, to the consumer reporting agency. So as soon as you're not talking about the consumer report, information coming from a third party to the consumer reporting agency, the background check company, it's extraneous information. Or I see a lot of these disclosure documents that have at-will statements in them. I understand that my employment will be at will, and I can quit my employment or be terminated at any time. Those kind of statements, that's fine for the back of your employment application. That's fine for other documents in the employment paperwork, but it can't be on this document. And employers are getting sued just for having this extraneous language in there, and the courts are agreeing with them because the law is pretty clear. This disclosure document has to be used exclusively for disclosing that you're going to procure a consumer report, and if you choose to include it on there, you can include the authorization on there as well. So go look at your documents. Is there anything on there that doesn't have to do with the consumer report? Not even just the background check, the consumer report, the information you're going to buy from a third party. So go take a look at that. And then another sign that you're working with an actual consumer reporting agency that's Fair Credit Reporting Act compliant. At the time that you order the background check, you should be having to certify that you've made the disclosure, received the authorization, and that you aren't going to use this information in violation of any equal employment opportunity law, and that you will make the pre-adverse and adverse action notices that are required by the FCRA if something negative is on the report that may have negatively impact or adversely impact the hiring decision. So what does that pre-adverse action look like? So you get the background check back and there's a red flag here. We asked the applicant about their criminal history. They said they had no criminal history, but we've got 2 theft by check convictions in the last 2 years for this person. Or they have a pending case for assault, and that's a red flag for us. Or they lied about their termination reason or their dates of employment or something like that. It doesn't line up. And we're concerned about that, and it may affect the hiring decision. If the information on the background check that you get back from the third party may affect the hiring decision, then before you make that hiring decision, or at least put it into effect, you have to give the consumer or the applicant, the employee, a copy of the report, the entire report, unredacted, just as you received it, and a summary of their rights under the Fair Credit Reporting Act, which is a document prescribed by the Federal Trade Commission that you can, and the Consumer Financial Protection Bureau, that you have to give to the individual before you take the action. And then you can also give them a cover page here that just gives them additional information about why they're receiving that information. And it's a good idea in that cover letter, which is not required, but it's a good idea to tell them how to contact the background screening company in case they want to dispute the accuracy of the information in the report. Depending on who you should see very few disputes of the information in your background check. It should happen like, you know, once every several years. It should be so extremely rare because they're just, most of your applicants, if there's something's on there, they know it's on there, and you know, they're not going to, in our experience, they don't take a lot of time to argue and dispute stuff that they know is accurate. And so if you're working with a good screening company, you're not going to see that instance very often at all. It'll be extremely rare that somebody disputes information. Another thing you should include in this, that we recommend including in that cover letter, again, it's not required, is just a statement that, hey, if the information on this report doesn't put, the information, doesn't put the circumstance in the right context, you can provide us additional information for us to consider before we make our decision final. And what we're basically doing here is tipping our hats to the EEOC and their idea of an individualized assessment. Hopefully, you've throughout the hiring process, if you followed our process, you've asked a really good criminal history question, and then when you asked a criminal history question, gave them an opportunity to give you individualized assessment information, additional information to help you put this criminal history that they have in context of who they are today. So you may look at education, what kind of work they've done before and after the offense, how long ago the offense happened, maybe personal references or professional references, all those kinds of things. You could do that right up front and collect it when you collect their criminal history information from them. Do it during the interview as well. But this is one last opportunity to do it. So the background check comes back, and especially if it's criminal history, include this kind of language on that cover report. It's not required. There's no law that says you have to, but it's just a good idea so that if you're ever challenged that you didn't follow the EEOC's guidelines, which are not the law, and you don't necessarily have to, but you really want to demonstrate if you ever get the EEOC asking if you were looking into if you violated Title VII, you want to be able to point that, hey, we did this all the way through this process. We gave them every opportunity to tell us their side of the story, and they never did. So you send them the pre-adverse action information, the copy of their report, and their summary of the rights, and maybe that cover letter. And now, just take a breath. The consumer has the right to dispute the information back to the background screening company if they disagree that anything is wrong, or they disagree with anything on the report. If they think it's wrong or it's not in the proper context or whatever, we get those kind of, you know, they can call us. 99.9% of the time they're just mad, and so we're sweet and lovable to them, and we just listen to them, and then ultimately after they've kind of you know, expressed their unhappiness, we go back to the core issue. So you're saying the information on the report is accurate though, right? And as soon as they agree to that, then there's not a lot, you know, more for us to talk to them about it. Now, I don't like my employees to get yelled at, so I invite, you know, if I'm in the office, I'm always glad to talk to the consumers and handle those conversations myself. And often I'll just tell them, hey, you know, there's, now that you've agreed that this information is accurate, let's talk about what it really means in the context of how to look for a job. Let me tell you, when I'm talking to former offender groups and reintegration groups that are helping people find meaningful work after having some sort of criminal history, here's the things I tell them, and I'll have a conversation with them about that. But if they actually dispute the accuracy of the information, we as the background screening company have 30 days to reinvestigate their claims that the information was inaccurate. But the law doesn't say that the employer has to hold that position open for 30 days, and you don't. Now, a few states have requirements that you wait at least 7 days before taking action, but those very few states' laws, nothing in most states require that. And if you're working with a good background screening company and they receive a dispute, they're going to resolve that dispute within hours, because they're going to pick up the phone and call the court clerk or call that previous employer and verify the information that they've already received and tell them, well, hey, this applicant says this and this and this, and the clerk will either approve it or verify it or not, say it's true or it's not, or the previous employer will verify it. Usually it should just be a matter of minutes or hours. On occasion, you actually have to still send somebody physically into the courthouse to do that, and that's fine too, and it can take an extra day or so. But if you're working with a really good background screening company, you should almost never see a dispute, and when they do receive one, it should be resolved extremely quickly, and they should be in real-time conversations with you about what the status of that is. And a lot of times you'll hear applicants say, well, that's just not me. That criminal history information is not mine. And sometimes they claim it. Often it is theirs, and they're just trying to bluff you. But on occasion, it does happen. This is a true story out of our own files. If you've watched other webinars or seen me speak live, I use this quite a bit. But we had an applicant who had a very unique name. That was fortunate for him. We'll call him Ezekiel Uriah Jones. It was a very unique name. There weren't going to be a lot of them running around out there with the exact same date of birth, certainly. And so we start the background check, and we find these records under this name and date of birth in Berkeley, South Carolina, and Navarro County, Texas. Okay, well, that's interesting. So he's got, from 96, a domestic violence and a DWI, and criminal trespass and theft and DWI out of Navarro County. And by the way, if you look closely, these are the same guy. Just between 1996 and 2002, he had some rough years, but that's him. So we're looking at this, but my team, because I hire very smart, thorough people, they came to me and said, look, he's got these criminal histories, but, and they're in these other places, and he served jail time in some of these, but he was constantly employed right here in Fort Worth the entire time. Something doesn't line up. It would have been hard for him to have the same employment all this time and been in these other locations to get in trouble and serve jail time. And so we did a little additional research, pulled the actual court files out of the courthouses to go through them, and we found that there were different Social Security numbers in these two court files. One belonged to a woman, so it wasn't his at all, and the other one had never been issued. So when he was asked the Social Security number, he just made it up. So now we're really intrigued, and so we ordered the mugshots, and we get these mugshots that you see here. And we call our client and say, okay, so tell me about Mr. Jones. And the client says, well, he's a well-respected social worker in the community, and he's highly respected and blah, blah, blah. And I'm like, well, tell me, what does he look like? And he said, well, he's a 6'2" black guy. And I said, oh, okay, well, this is not our guy. And we did additional research, and you can read about this on our blog on the website, but we did additional research and talked to the applicant, actually. And he was surprised by this. And he said, though, that when he was in the military, his identity was stolen in the mid-90s, and somebody had opened a bank account and some other accounts under his name, and caused a big mess. And he thought he had rectified all of that. And he was surprised that, 15 years later, all this stuff is popping up. But he did say every time he gets a traffic ticket, the police would get his information, they go sit in the squad car, and they would sit there for a long time. And he was convinced after I told him about this, he had no idea this guy has these records under his name. But he was convinced, oh, wow, I've got a, that's why the police officers are trying to reconcile. They're running it and it's popping up. This guy's got some criminal history, but then they're seeing the demographic information and they realize it's not, the name's the same and all that, but it's not the same person. So all that to say, just because your applicant says identity theft doesn't mean it's true, but on occasion it could be. And so let's always just take a deep breath, let the background screening company do their research, figure out if it's really them or not, and then move forward. But once you make the hiring decision, once you say, okay, we are not going to move forward with this person. We gave them the pre-adverse action stuff. We gave them a copy of their report, a copy of their rights under the law. We took a breath. They're not disputing the information. We're good. Then we can make the adverse action notice. And that last adverse action notice basically is what we suggest you have in the cover letter as well on the pre-adverse action notice. You got to tell them what you're going to do. We're going to rescind the offer, or we're going to, eliminate you from consideration. You've got to give them the information about how to contact the background screening company. You've got to give them actually has to have a statement that the consumer reporting agency, the background check company, did not make the hiring decision, okay, and is unable to provide the consumer any information about why you weren't hired. And then you got to tell them that they can get a free copy of their background check from the background screening company in addition to the one that you've already provided them. And that's the adverse action process. And so many employers screwed this process up that they get sued for it. And it's really pretty straightforward. Our online system and many background screening companies' online systems will automate all this for you. If you've got the applicant's email address, it'll send them an email where they click on the link and they go in and get their information. And every time they look at that report, it creates a time and date stamp and an IP address is recorded, so you know when they looked at it. So it's really easy to follow this stuff. You just got to have a process in place to make sure you follow it every time. So I'm going to go back and try to answer any other questions we have. Okay, the question is, can we rescind the offer because the applicant did not disclose not having a driver's license? Okay, well, here's the question. Yes, you can. I mean, certainly, there's no reason you can't. If having a driver's license is required for the job, then certainly you can say, well, you don't meet the requirements for the job. Maybe not having a license isn't required maybe having a license isn't required for the job, but you asked them during the process, do you have a valid driver's license? And they said, yes. Then they lied on the application, and you can do that. Certainly you can act on that as well. So that's I would have to know more about the circumstances about how you had that information, why you understood that they had a license, but I would always want to know why they don't have a license. If somebody's been denied reinstatement of their driver's license, there's a reason for that. And at the very least, I would go back to your applicant or your candidate and say, okay, we see there's a red flag here. You don't have a license, and it's not because you just didn't want one. It's, you were denied reinstatement. Your license isn't valid. It's not required for the job to have a license, but there's something going on here. We want to understand why it was denied, because there could be other issues. There could be warrants from other jurisdictions, unpaid traffic tickets and warrants for your arrest for that, or maybe you couldn't renew your license because you owe back child support or there's other issues going on. We want to know what that is. We want to understand why you don't have your license after, for whatever the reason is. And then we'll evaluate, is it relevant to the job? But until you know what that information is, you don't know if it's relevant. And you've got a red flag here and you don't want to ignore it. That's gospel according to the coffee stuff, but I feel real strongly that applicants need to take care of their personal business before they come work for me. So if I see a theft by check warrant for arrest 7 states away, and that applicant says, oh, I'm never going back to Pittsburgh, why should I even have to worry about that, taking care of that stupid warrant? Well, you take care of your personal business before you come to work for us. We require nobody can have a warrant for their arrest when they come to work for us. We don't want you going to lunch, getting a traffic ticket, and not coming back. Plus, it's just a sign that they don't take care of business. Really, do you want to hire somebody who's got that kind of attitude? I've got warrants for my arrest, I've got this and that, but they're never going to get me. Well, that's not exactly what you call somebody who's going to be responsive to your company policies and procedures, who's going to be compliant with your rules. They just self-identify to you that they're kind of a knucklehead. And again, past behavior is the best predictor of future behavior. And so, and the more recent the behavior, the better. And the more relevant it is. But even some older behavior, depending on what it was, may really, if you pause, they're currently pursuing a degree at a college, but when I called the college and it said he took one class in 1997, I would consider that a lie, correct? Yeah, if they're not enrolled and they haven't attended that college in 20 years, yeah, I would say they lied to you. And that's, we see things like that a lot. We see more, actually, I think we looked at the numbers a couple of years ago. We have more people lie about their college history, their college degrees and education history, than we have lie about their criminal history. So think about that. People are more honest about their criminal history than they are about their education. We see a lot of people who just make stuff up. They claim degrees to try and be more qualified for the position. And unfortunately, they lie on the application to seem more qualified, but they've just self-identified to you as a dishonest person, and I would disqualify them from consideration for the position immediately. And just like you fire somebody for lying to you as an employee, you certainly want to eliminate them from consideration now or in the future if they lie to you trying to lie to you coming in the door during the application and interview process. And let's see if I think I answered whatever questions you had. I don't see any other ones, but do download the book. The 7 Steps book covers the entire employment screening process that I think employers should really consider implementing. It helps you better consider individuals with criminal history. I think it'll help you defend yourself if anybody ever tries to bring a disparate impact claim against you for a Title VII type violation. And it's just a good practice. It just helps you be a fair, more thoughtful, better employer. And most of it's not about background checks. I mean, I sell one thing, background checks. And if you don't absolutely love your background screening company, please give me a call. I would love to work with you. Now, what we want, I'm not going to sell you some cheap $20 background check that's delivered in 15 seconds. We only want to work with employers who really want to get it right, who recognize that the hiring decision is the most expensive decision they're going to make in their company, and it exposes them to a ton of risk, and they want to do it right the first time. I want to help you do that. But the entire 7 Steps book is available to you, and it's got that whole process, and it's got the tools, the criminal history question we recommend employers ask. It's got all the links to all those kind of resources as well. So please download that if it's helpful. If you've registered for this webinar, you're not just watching it on Facebook, but you've registered for it, then you will, at the end of the webinar, you'll get an email with a link to a survey just to kind of tell me how I did. And also, give me feedback. This is a brand new office for me, and you can see out there and see the actual employees working. Is that too distracting? I'm going to have blinds installed eventually, but is that too distracting? Tell me that kind of stuff as well. But once you complete that survey, then you will get the link, or you'll get the HRCI and SHRM recertification information and a link to download the notes, because my slides are pretty much just pictures. And so, but for every slide, there's a set of notes that kind of cover what I was going to talk about and should be helpful to you. But most of it is also in the 7-Step book. So that is where I will end the webinar. I hope you found that helpful and a good use of your time. And again, if you don't absolutely love your current background screening partner, please give me a call. I'd love to work with you. Have a great one. Bye-bye.